S. Sahaj Vidhi www.sahajvidhi. In Question 1. In case of joint offenders, their liability is joint and separate. Explain the conditions when such principle is applicable. Model answer. The principle that the liability of joint offenders is joint and separate, or joint and several, is a crucial concept primarily in the law of torts, though analogous principles exist in criminal law regarding common intention or common object. This principle means that when two or more persons are responsible for the same tortious act or the same damage, each of them is individually liable for the entire damage, and are also collectively liable for it, meaning of joint and separate liability. Joint liability. The plaintiff can sue all the tortfeasors together in one action. If a judgment is obtained against them jointly, they are all responsible for the full amount of the damages awarded. Separate, or several, liability. The plaintiff can choose to sue any one of the tortfeasors individually for the entire amount of the damage. The plaintiff is not required to apportion the blame or damage among them. If the plaintiff recovers the full amount from one tortfeasor, cannot then recover more from the others, though can pursue contribution from the other tortfeasors. Conditions for applicability. In torts, this principle applies when two or more persons are considered joint tortfeasors. Joint tortfeasors are those who are responsible for the same damage, either because they acted in concert or because one is vicariously liable for the other's actions. The main conditions are: 1. Common design or concerted action. This is the most direct form of joint tortfeasance. It occurs when two or more individuals act together in furtherance of a common plan or design, and their combined actions result in the same damage to the plaintiff. Each person is responsible for the entire damage caused by the joint act. Example: if A and B conspire to assault C, and both participate in the assault, are joint tortfeasors. Similarly, if two drivers engage in a street race and one of them negligently causes an accident injuring a third party, both drivers could be held jointly and severally liable if their racing was a concerted action contributing to the risk. Case law. In the Korsk, 1924, it was held that persons are joint tortfeasors if they are responsible for the same tort, either because acted in concert or because one is vicariously liable for the other. This case distinguished between joint tortfeasors and independent tortfeasors whose acts merely cause the same damage. They. 2. Vicarious liability. This arises when one person is held liable for the tortious act of another, even though they did not directly commit the tort. The most common example is an employer being vicariously liable for the torts committed by their employee in the course of employment. Example: if an employee negligently drives a company vehicle and causes an accident, both the employee, as the direct tortfeasor, and the employer, vicariously, are jointly and severally liable for the damage caused to the third party. Case law. Cassidy v. Ministry of Health, 1951, is a classic example where a hospital was held vicariously liable for the negligence of its staff. 3. Independent but concurrent acts causing single indivisible damage. This is a more complex scenario. Sometimes, two or more independent acts of negligence by different individuals combine to cause a single, indivisible injury to the plaintiff. In cases, if it's impossible to determine which part of the damage was caused by which defendant, they may be treated as jointly and severally liable. Example: two cars, driven negligently by A and B independently, collide and simultaneously hit C, causing a single, severe injury to C. If the injury cannot be reasonably apportioned between the two impacts, A and B may be held jointly and severally liable for C's entire injury. Note: if the damages are clearly divisible, then each tortfeasor is only liable for the damage caused. Right of contribution. While each joint tortfeasor is liable for the entire damage to the plaintiff, there is generally a right of contribution among them. This means that if one tortfeasor pays the full amount of damages to the plaintiff, can then seek contribution from the other tortfeasors to share the burden equitably. Analogy in criminal law. Common intention/object. In criminal law, Sections 34, Common Intention, and 149, Common Object, of the IPC embody a similar principle of joint liability. Under these sections, if a criminal act is done by several persons in furtherance of a common intention, Section 34, or in prosecution of a common object, Section 149, Each of those persons is liable for that act in the same manner as if it were done by him alone. This makes all participants equally responsible for the crime, even if only one person physically committed the act. In summary, the principle of joint and separate liability ensures that a wronged plaintiff can recover full compensation for their damage from any or all of the responsible parties, simplifying the recovery process and placing the burden on the tortfeasors to sort out their respective contributions. Please visit our website www.sahajvidhi.in for more content such they.